Good evening, everybody, for another of our 2021 webinar sessions online still. Welcome, everybody. Just letting people in. Tonight's topic is about how we deal with the issues on public access, which I suspect may become more important as we go into the new world of Elm and one thing or another, and clearly has raised issues both positive and negative, I think, over the last 12 months, 13 months even now, since the initial lockdown last March. Positively, obviously, we're seeing lots of people wanting to access the countryside, make use of the natural environment, maybe some even wanting to understand what we do. Sadly, a few people not able to respect the countryside, and I think we'll learn a little bit more about perhaps how we deal with that. But I think it's important that as farmers and people living and working in the countryside, we do have to find a way of working with the general public, I think, because they can be a very good source of income, both for people with diversified enterprises and I think going forward, probably with Elm and the bit of a focus of one of the 6 things that DEFRA are looking for being access. So we may much prefer to have nobody come on our land or our farm, but I suspect it's something that a lot of us will have to deal with. Obviously, farming in one of the less beautiful areas of the country, it's less of a problem for us, but probably more of a problem for many of you. So it'll be interesting to learn tonight about how we perhaps do deal with it in a positive and constructive a manner as we can. And I think part of it is probably educating the public as to how to use the countryside and what is acceptable and what isn't acceptable. And that's not always easy. I think it's quite difficult to educate the general public at the best of times. So I think we can we'll be interested to learn from Pippa, Catherine and Tom tonight how we might go about doing that. So just a little bit of housekeeping before we get underway. In a couple of minutes, we'll give it a couple more minutes to allow people to join us. Just to be aware though to everybody, and I will repeat this, that all our webinars are recorded, edited and available on our YouTube channel, as well as in the news section of the TFA website. I hope that Julie's organised that in anticipation of people not attending, and that there aren't too many people who are perhaps spending even more time on webinars and watching it for a second time, but you never know. We might find something very, very interesting tonight that we need to recap on, but I'm sure we'll be very clear. So it is recorded. Secondly, a huge thank you once again to Barclays for sponsoring this series of webinars. Barclays are big supporters of the TFA. We really appreciate their input and their support to the organisation. So a big thank you to Barclays as ever. As I said, tonight's focus is designed to help us as tenants to deal with issues around public access and safety. And we're being joined tonight, and a big thank you to all of our speakers, by Pippa Langford, who's the Principal Specialist for Recreation and Access at Natural England. And she's going to talk us through the Countryside Code refresh and offer some best practice tips for us as farmers. And then after we've heard from Pippa, we'll hear from Catherine Harris, who's the Head of Agriculture and Food, and Tom Hickingbottom, who's a Senior Solicitor at Wilkin, Chapman, who will discuss public rights to access the countryside. And I think both of those will be, as I've said just now, very relevant and really interesting. So I'm looking forward to hearing from all 3 of those. And as always, we're joined by Linda Davey, who's from GRP, who's the TFA insurance provider. As many of you will know, we've GRP sort of picked up the baton on our insurance scheme last year, and by all accounts are making some really good inroads into helping out us as farmers to get our insurance right and our cover right. And we really appreciate the time that Linda gives up every month to come and talk to us briefly on a range of topics. Tonight, she's going to talk to us about the importance of public liability insurance and occupiers liability insurance and how to assess safety of the public on the farmland. So very topical as ever, Linda. So thank you very much for joining us. Just as a quick reminder, we have had some questions, and there will be an opportunity to put questions to all of the panel later towards the end of the evening after the presentations. There is a Q&A button at the bottom of your screen, and I would ask you if you have got questions, please put it in the Q&A, and we will do our very best to pick it up. For those questions that we don't manage to answer this evening, we've asked Pippa, Catherine and Tom if they wouldn't mind giving up even more of their time to just answer those, and we'll publish those on the website, and graciously they've all agreed to do that. So thank you all for doing that, because it's really good that you've given up this evening to come and talk to us. So I think without further ado, we'll make a start. So over to Linda to talk about public liability and occupiers liability insurance.
Oh, good evening, everyone. Thanks very much, Mark. So my name's Linda Davey from Marshall Waldrich, part of the GRP group. And tonight, a very, very wide topic of public liability insurance. But I wanted to just pick out a tiny bit that might be not covered by the other speakers, which is the difference between your motor insurance and your farm insurance as far as public liability is concerned, because this applies whether you're an owner of the farm or an occupier, and can be just as onerous. So if you've got a motor policy, farm fleet policy, for example, it will cover your motor vehicles, and that actually complies with the terms of the Road Traffic Act, which says you have to have compulsory insurance on a road or in other public places. Public places extend to bridle paths, car parks, footpaths. So that's where your motor insurance comes in to comply with the law. Your farm insurance, your public liability on your farm insurance will generally pick up unregistered motor vehicles, so liability for injury to third parties for following the use of an unregistered motor vehicle. So all your unregistered quad bikes, your scraper tractors, your diggers, all the things that you don't think require compulsory road insurance can be picked up under your public liability insurance on your farm. So that's how the situation has always been in UK law. However, there's always a however. In 2014, there was an incident in Slovenia, where a third party called Vanuk, I think his name was, he was struck by a trailer and a tractor whilst he was working on a building. And the problem with that is that it brought into the fore all of the issues around whether you really ought to have compulsory motor insurance when you're on private land. And this has been a hot topic for years and years and years following that, because it went to the European High Court to decide whether there should have been, because there wasn't in place any sort of fleet insurance, any motor insurance to cover the injuries to that unfortunate victim. So as a consequence of that case, I mean, Boris Johnson actually said that it was insane, and because it actually said that the upshot of it was that everyone is required compulsory insurance on both public and private land. So you can be bombing around your fields in your unregistered quad bike, and the European law said you had to have it insured for under a motor policy. It also extended the definition of vehicle insurance to a much wider definition, which included, and this is quite remarkable really, but included the possibility of ride-on mowers, mobility scooters, children's toys, fairground dodgems, segways, all the things you wouldn't normally ever conceive that could be insured under a motor policy. So the whole thing has been in the air for years and years and years. And the problem is with it is that it could have ramifications on the farm owner or the farm occupier, in that if you have an accident with one of your uninsured vehicles on private land, you could end up being liable for that accident under the Road Traffic Act. And if you haven't got motor insurance that complies with the Road Traffic Act on your private land, you could potentially be prosecuted for no insurance. So the upshot of it is recently, only in February this year, that the Department for, I think, Secretary of State has decided that they're not going, following Brexit, they are not going to go down the road of following the European rulings on this type of incident. So everyone sort of breathes a bit of a sigh of relief on that point. However, it doesn't mean that in the future we're not going to go down that road. So all I'm trying to suggest is that if you've got the unregistered vehicles that they use on the farm and you're relying on your farm insurance to pick up any liability for those, if you hit someone or you cause damage to someone's property, if you're relying on the farm insurance, then don't. Put those vehicles on your motor fleet insurance, and belt and braces, that will cover you then if the UK law ever decides to follow the European rulings, and basically could leave you in a very, very difficult position without any insurance that is valid for your accident. So that's my advice today. I could go on forever about other public liability issues, because occupiers' liabilities is a huge subject as well. And we're all very well aware of the increasing costs of claims for injury following all the Ministry of Justice amendments that went on a few years ago. So just be aware that you can increase your public liability insurance especially if you're in a situation where you have public on the premises regularly. So if you're an open farm or you have a petting farm, anything like that, if you have regular visitors in large numbers to the premises, you might want to look at your overall 10 million, which it should be as standard, but possibly not. And you can increase it to 15, 20 million. Of course, there are financial implications for that, but it is possible to do it. So just in case you're in that situation, then bear that in mind, and also bear in mind all your unregistered vehicles that I would really strongly recommend you put on your fleet. I think that's about all from me, Mark.
Thanks, Linda, as ever. That's it's always good. I always come away from these little spots that you've had in our webinars thinking that it is nice to be dealing with people that have some real knowledge of insurance and what we're talking about, and probably, particularly in light of tonight's subject, a really useful reminder for people to just think about how the public are accessing their land and whether there is an increased liability as a result of it. So thank you very much for Linda. And as I say again, if you have questions, please put them in the Q&A. So we'll go on to Pippa Langford, who, as I said earlier, is a principal specialist in recreation and access for Natural England. She's going to update us on the Countryside Code and a whole load of other stuff about public access. So over to you, Pippa.
Thanks very much, Mark, and thank you to the Tenant Farms Association for inviting Natural England to speak. Yes, I'm going to cover the Countryside Code, which you may have noticed has been refreshed this year. Particularly over Easter, you may have noticed quite a lot of publicity about the code. Julia, it doesn't seem to be moving. Sorry, we did practice this. The code has been around for 70 years. So it's not a new thing, and you may have noticed earlier versions and earlier things like the Ardman publication, but now we've just updated the code, and we're very much trying to use more modern language and terms that younger people might recognise and empathise with. So we did a review of the code, and we invited stakeholders to feed into our consultation. And Helen Radmore from the TFA actually participated in that review. We got lots of response to an online survey, And then the refresh code got signed off by Lord Gardner and our own Chief Executive, Marion Spain. And then we've started work on a communications campaign. And very much we're trying to get people to use the countryside safely. So we've changed some messages and tried to be more approachable. So be nice, hello, say hello, share the space. But we have kept some key messages as well. So don't feed livestock, horses or wild animals. Stay on the footpath. We did revise it to make it clearer that dog walkers should take their dog poo home with them if there isn't a bin that they can put it in. And what we've tried to do is we've tried to move it to a guide rather than a list of do nots, which we know after a while the public just switch off and don't listen anymore. So we're also extending the code so it's all natural places and it includes parks and waterways and coast and countryside. And so this is what the summary of the code now looks like. You can download this from the website and you can print it off and you can laminate it and you can stick it around so that people can see it. So it's got the key messages that you might want to pass on to the public. So be considerate, leave gates as you find them, which has been the message for quite a while. Don't block access to gateways, follow local signs, keep to marked paths, take your litter home, don't light barbecues, don't light fires, keep dogs under control, bag your dog poo and take it home, care for nature, don't disturb it, and enjoy yourself. Check your route before you leave, check local conditions, plan ahead, and generally have a nice time. And we have a second sheet which reminds people about what footpaths, bridleways, restricted byways and byways open to all traffic are, because we realise that quite a lot of people don't know what you can do on different statuses of public rights of way, and they probably don't know about permissive paths, national trails or open access, so we've reminded them of those as well. So long term, we're going to have a campaign. You'll probably notice it again over the summer. And there are occasionally hashtags that you're welcome to share. We'll be doing some educational work. We're hoping to work with the Department of Education. We are looking for sponsors. And we're going to be going to social media influencers as well, because we recognise that old-fashioned ways of communicating with younger people don't work. And we're basing it very much on behavioural insights. So how to get people to change their behaviour. Because that's quite a science these days, and telling people what to do just generally doesn't work, but nudging them we find works better. And we are looking into having a dedicated web presence as well. So we are thinking of updating the Land Manager Code. You'll be aware that there was an old one. We're also thinking of having some special interest codes, maybe a mountain bike code, and maybe we've already got a dog walker code, wild swimming code. We're looking into that. We haven't made decisions about that or not. And of course, we're going to evaluate and monitor how effective the code is. Is it working? And we're definitely exploring options for a sort of countryside code portal and Facebook pages and social media things and Twitter and all the things you would expect these days. So, I was also asked to talk about best practices for landowners and tenants. And I thought, how best to tackle this? How to help you get better results from people who come onto your land using public rights of way or who are trespassing. And I thought the best way to do this is probably to try and think like a dog walker or a person with kids or whoever it is that you're finding, and think, what is it they are trying to do? What do they need to know? And often the key thing they're trying to find out is, where can I go? Because lots of people don't understand about where they can go. And so they are looking for visual clues about where they can go. They're looking for signposts and waymarkers. And if you can help them by making it obvious as where to go, that will probably help them stick on the path. And dog walkers are often looking for places for letting their dogs off a lead, because that's their key driver. They really want to be able to let their dog off the lead. So if you can point them to places where they can let their dog off the lead safely, they're less likely to be letting their dog off the lead where they shouldn't be. And they will need to know things like, should I shut the gate or not? And do I need to put my dog on lead? And I've put in brackets now, because timely messages work really well. So what are the key things that walkers and other users of the countryside need to know? Well, they don't want to get lost. They don't want to be in the wrong place. They don't want to fall over, get muddy, lose boot, get the kids muddy, get chased by cattle, get shouted at. They actually want to have a nice time. And if you can help them to have a nice time, you'll probably find that you get into less conflicts with them. But it would be useful to know how many people we're dealing with. And the answer is a very large number. So out of that very large number of people who go into the countryside, there will always be a few who aren't going to listen to messages. And I know there's some questions at the end about how to cope with people who aren't doing the things they should and aren't in the places where they should be. But it's just to note that there's a very large contribution to the nation's health and well-being from people getting out on land which is managed by farmers. But where do they go? They go, I can get the slide to move on. They tend to go very close to where they live. So 68% are within 2 miles of the start point. So normally 2 miles of where you live or 2 miles of your holiday base. 64% are on foot and 78% are less than 3 hours duration. So people who come onto your farm are really likely to be locals. And that's really useful to know when you're trying to persuade them to do the right thing. So what do they need? Well, the first thing that users want is they want to know where to go. And so I would encourage you to have a look at signposts and waymarkers on your farm. And if they aren't really clear, and you kind of have to get somebody else's head on because you know where the path goes. So in a way, it might be useful to get somebody who doesn't know where the path goes to come along and walk the paths on your farm and go, well, I couldn't work out where to go, or I got a bit lost here, or I couldn't see the waymarker. Because if you can see the waymarker from one field boundary to the next, you'll tend to follow the path. If you can't see a waymarker or where the path goes when you go into a field, that's when you're more likely to wander around a bit and maybe freelance and go somewhere else. So follow the good practice on signposts and waymarking. What else do you need? A good surface is good. The example of the non-ploughed bridleway is just near me, and it was really recent, this picture. So if you do have arable fields and you have crossfield paths, if you're having that problem that people are spreading all over the place, then maybe it is an idea to think about, well, could I not plough it? Is it possible? I mean, this is a bridleway, so it's fairly wide. But is it at all possible to plough the field to leave the surface so it's really obvious to people where they should go? And if you can't not plough it, then make it really obvious somehow. Maybe some sticks across the path, as well as some wheelings, make the surface good. And then across grass fields, you can mow the line of the path. That's really helpful, especially if you've got long grass crop, maybe a silage crop. If you mow the line of the path, that's where people will go, because they do follow the line of least resistance, and walking through long grass is not what most people do. So in this picture, you can see where people have gone because they flattened the grass. But if you're not getting people to stay on the path, then maybe mowing the path will help. Users also need accessible structures, and these probably aren't your responsibility because they're the landowner's responsibility, but maybe you could have a chat with your landowner, because if the accessible structures are good, then people are less likely to stray off the line of the path looking for a way through because they can't climb a rickety old stile, which isn't very good. So there's a British Standard 5709, which helps you to actually install usable, robust structures. And this is what an accessible gate looks like. And that actually is our Deputy Chair, Lord Blencathra, trying out an accessible gate at our National Land Access Centre at Aston Run National Nature Reserve, which anybody can kind of have a look at if you want to. And the other thing about an accessible gate is if you have accessible bridleway gates, horse riders can use them without getting off. It also means that they're not moving their horse around an awful lot, making a mess of the ground. An accessible structure is easier to use, and so therefore you get less compaction and less erosion around the gate. So some timely tips. I thought what's probably going to be most on your mind, and it's probably dogs and sheep. If you can, it'd be really helpful to put up fresh notices about sheep in the field and take them down when they're not. And sometimes use humour. I've seen humorous cartoons about sheep and dogs, and I've seen them be effective in that I've never seen a dog off the lead in the field where there was humour used. And maybe you might want to make it personal. It's a message from the shepherd Tom, or whatever you want to call yourself. Because then people relate. This is a person talking about their sheep and their lambs, not just a faceless farmer who isn't real somehow. But I urge you not to make it gruesome. I've seen some gruesome pictures, and whilst it's tempting to put up gruesome pictures, we know that the public switch off and they don't look at them. There's a sort of inbuilt resistance to looking at gruesome things, so they won't take in the message. So I'd suggest that you use humour, make it approachable and friendly and personal, and you're more likely to get a good reaction. It also helps if you provide information where dogs can be let off the lead. If there is anywhere on your farm where there isn't livestock, then and there's a public right of access through it, then let people know, because then they're more likely to go there, and that's where they'll let the dog off the lead. And I know some farmers are looking at paid for off the lead areas and making money out of this. So maybe if you have a lot of demand for dog walking, then that's the thing you could do. I'd also urge you, because most of the people coming on your land will be local, they'll be within 2 miles, and they'll be repeat visitors. So if you can, say hello, have a chat, and start to build a few relationships, and get some other people who will act as your eyes and ears as well, and who will voice the same things as you would when they see people doing the wrong thing. You might not know about it, but you might see the impact of that. And then finally, I thought, what to do if you find someone who's off the path. The best thing to do is go and talk to them and assume that they're lost because they couldn't see where to go. And ask them, are you having a nice time? And do you know where you're going? And are you lost? I think you must be lost because you're not on the path. Do you know where the path is? And try and be positive about getting them back onto the path. Because then you'll let them save face, and they'll be able to go off onto the path and think, well, that farmer was nice. And we'll try and do the right thing next time, we hope. No. So finally, there are quite a few sources of information, which I've put the links to. So there's lots of information about how to get better access and things like the Countryside Code, which you might want to download and use on your own farms. Thank you, Mark.
Thank you, Pippa. That's very interesting. Some really good tips there. I think the takeaway message from there was on the tip side was definitely sort of try and look at it from their point of view a little bit, and we might sometimes be a bit grumpy about trying to do that, but I think it's really important that, particularly as you mentioned, the number of people that are locally accessing public footpaths and whatever, and try and build those relationships. It doesn't eliminate issues, but I'm sure it helps in the long run. Could I just ask quickly, because this isn't really a detailed question, but the signs and stuff around the Countryside Code, are they downloadable, and we can laminate them and put them up if that's the case? And
yep.
Do Natural England have a policy of making all of those present on sort of car parks and public places? Is there a plan to put them up there? Because I think having them where people stop to get in could be really useful.
Well, we're certainly working with lots of partners to promote the code and encouraging them to use it. So hopefully you will start to see it on car parks, local authority car parks, Wildlife Trust car parks, RSPB car parks, places like that. But if your members know where people park, and there is a handy post where you could put the countryside code, maybe that's something you could do.
Brilliant, thank you. Okay, thanks very much, Pippa, again. And so we'll move on to Catherine and Tom from Wilkin Chapman, who are going to tell us a little bit more about the legal side of what we should and shouldn't be doing. So over to you, Catherine.
Very much, Mark. Yes, so I'm Catherine Harris, Head of Agriculture and Food at Wilkin Chapman Solicitors, and we're based in Lincolnshire. And I'm a TFA recommended professional. I'm very proud to be so. So this is the first time I've spoken on a webinar. So just a little bit about me personally. So I'm a farmer's daughter just over the border in North Nottinghamshire, and I live next door to the family farm. Now, where I live, the soils are very good soils, but it's a little bit flat. But whilst I've been working at home over the last year, and I've got a public footpath right outside, I can see it from my office window, and it goes across my family farm. I've noticed a huge increase in use, and it's dog walkers, it's horse riders, even though it's a public footpath, and also motorcyclists, the noisy types without registration numbers. So I do see, firsthand a degree of conflict arising. And, public rights of way, they are an opportunity, and increasingly in this landscape of public money for public goods. And we've got to think differently about them. And what Pippa said was, really some really good information there and about engaging with the public. So I'm right on board with that. But on the flip side, there's also a level of anxiety, I think. So it's about risk management, different levels of liability, and having an all-important insurance, and things about inadvertent creation, permissive paths, and can they become public rights of way. So I'm joined this evening by my colleague Tom, who's a senior solicitor in our dispute resolution and an expert on this area. And this evening, Tom's going to talk to you about four main areas. Look, this is a huge area, but we've narrowed it down to four main areas, and which we thought would be most helpful for you. So the first area is public rights of way, registration, creation, how you oppose the creation of a right of way. We're seeing a number of applications going into councils for registration of rights of way. So Tom will talk about that. Secondly, public and private rights of way, the differences, permissive, and the difference in liability there, and also rights and responsibilities of landowners and occupiers. And that's when it comes to things like livestock, dogs, and trespassers. So, and then finally, we're just going to look at the tenancy provisions, because there's usually provisions in tenancy agreements about what you can and what you can't do, and about rights of way. So Tom will just take you through some of those as well. So I'll pass you over to Tom. I might just chip in just to draw out some of the issues. So Tom, over to you.
Thank you very much, Catherine. I did practice this early today and massively ran over, so I'm going to rattle through everything as quickly as I can. And then if you've got any questions, please ask them at the end in the Q&A box. I will try and stick to the timings best I can. So with that in mind, I'll crack straight on with public rights of way. Most of what I'm going to talk about is in respect of the rights of way in England. There are some differences for Wales. But most of it will cover both. There will be some differences for Wales, so just to make you aware of that. And of course, we talk about new public rights of way, but by the time that they come for registration, they're not new at all. They will have, in most cases, been exercised for at least 20 years, and that's how you come to register them. So where you've used a right of way for 20 years as of right, and that has been without force, without secrecy, and without permission, you can then apply to modify the definitive map. There are other ways of doing that, and historic dedication of rights of way is commonly used. That's what we see on a fairly regular basis. But I'm going to concentrate on just the Highways Act very briefly, and how they go about being added to the definitive map.
So Tom, just before you move on, that you mentioned that 20-year period. Do you want to just explain briefly how that's calculated?
Yes, so the 20-year period, that is based on the date that the right becomes interrupted or challenged in some way. So that might be simply that an application is made to modify the definitive map, in which case that 20-year period is looking back from the date the application's made. It might be that the right of way becomes restricted, the gates are locked, notices are put up, or the use is challenged in some way by the landowner or the occupier, and that 20-year period is calculated from the date that happens. So now that we know how a right of way is created, how can it be prevented? Prevention is cheaper than the cure, and it is not a good idea to turn a blind eye to it. Depositing a map and a statement with the local authority is going to be one of the most effective ways to prevent new rights of way being created. That needs to be done every 20 years or whenever the ownership of the land is changed. Signs and notices on the land, distinguishing between permissive rights of way, public rights of way, will help. And keeping evidence of those signs and notices, renewing them when they become illegible. Locking gates for areas that the public can't access. And as Pippa quite rightly said earlier, talking to people who aren't in the right place, challenging them. If you do it in a friendly and approachable manner, very much in the way that Pippa described, it's going to go a lot better. It sometimes can be daunting for people to be challenged, but most people do want to enjoy the countryside and don't need to go where they're not allowed. Granting permissive paths is frequently something that's done in order to encourage use of land, but not create a right of way, and that may have implications for insurance. But keeping records is key to preventing the future acquisition of rights of way. And I just want to briefly touch on the process because it can be a shock and it can be upsetting. In most cases, the first time an occupier, a landowner, will learn of it is the date that their notice is posted through their letterbox. That is the process to apply. A notice is given to the landowner or the occupier, an application is deposited with the local authority. And I'm going to quote Natural England statistics. I don't know whether Pippa agrees with these, but the statistics I've seen, that there are 4,000 paths currently being pending registration through definitive map modification orders. She's nodding to me, so I think I've got it right. And they may take 13 years to be registered. I know certainly I have experience of one case where the chap has been waiting at least 10 years to see a definitive map modification order be processed by the local authority. So these are long-term challenges that landowners face. And once a local authority has confirmed their investigation has been done, they then make an order, and that is at the point at which it can be challenged. Now, that should be challenged within the specific time period. So it's important that people keep an eye on these things. And if there is a challenge or the application's refused, then it's down to a planning inspector to make a final determination at a public hearing. And that is, like I say, could be over a course of 10 years, that period. In terms of sorry, before I go on, just in terms of that process, procedural points are procedural challenges to the process, either good grounds for objecting. Also, the evidence is what's going to be key to be challenged. While on the subject of definitive map modification orders, I just want to touch on upgrading, so changing a footpath up to a bridle way, or a bridle way for all traffic. That process is the same, so still going through the definitive map modification order if there's going to be an upgrade. So it can, again, be a long process. The registration of historic rights of way uses the same process again. In that respect, there is a little bit of light at the end of the tunnel, because in 2026, you won't be able to record historic rights before 1949. If they haven't been registered and recorded, that's still a long way off, though. And I know the Ramblers Association are on a mission to make sure every new right of way, every existing right of way is recorded. It is possible to temporarily close a right of way with the permission of the local authority for up to 6 months. Be relevant if you were carrying out development work, changing things on the holding. Permanent diversion is possible as well with permission of the local authority. I know that the TFA's had speakers before that have talked about that in more detail, and each case is dealt with on a case-by-case basis. Diversions are possible, but they will be treated on their own merits, as will the stopping up of a right of way. I have spoken to a couple of people this year who achieved it with the support of the local authority. So it is possible, it can happen, but it won't be possible in every case, and they are treated on their own merits. I just want to go on then.
Yeah, sorry, Tom. I was just going to ask, just to draw out there. So if an application is made for a new right of way on land, what are the grounds for objecting? Do you want to just
yes, so certainly the principal ground for objecting to a right of way is going to be the evidence. What evidence has been presented? Normally, it'll be in the form of statements by people who have used the right of way locally. You want to check for inconsistencies in those statements. You want to check for evidence of actual use. It may be completely impossible to use the route that's been applied for, either because somebody's marked it on the map incorrectly when they've made the application, or because the person doing it has never actually visited the land. I've seen both happen. So it is important to check that evidence, to investigate whether there were statements and maps lodged with the local authority, and make sure that everything is in order. It's not always possible to challenge it, but the evidence is the best way to go about it. So I'm going to just move on very briefly to talk about private rights of way, just because there's some key differences. The first being a private right of way serves a property. It's not open to the general public, and it's either express or implied. It still has to be created if it's implied without permission, without secrecy, and without force. But it is more difficult to obtain, certainly against tenanted land. And I think that's relevant when Catherine and I come on to talk about the provisions within tenancy agreements later. And generally speaking, the duty of care is slightly different because if it's been an express grant, then the person will be a lawful visitor. And so the consideration in terms of liability.
So, Tom, just on that, actually, I think, is it possible for a private right to become a public right? Have you, in your experience, have you seen that sort of happen?
I haven't seen that happen, but in theory, I suppose it's possible. If a right of way was used by private individuals benefiting a piece of land, but over the time public came to use that piece of land, then yes, it is entirely possible. And especially if you don't know who should or should not be exercising the right of way. Challenging people who come onto the land makes it a little easier. So I'm going to talk about just very briefly some responsibilities and rights of landowners. And in particular, one question I was asked to comment on was whether new features, so styles, cattle grids, kissing gates and things like that, could be put onto public rights of way. And the local authority does have the power to grant permission for new features to be put on. Now, as a tenant, you might not want to do those. As a landowner, you might want them. It's a balance. There will be obligations on the landowner or the occupier to maintain those structures, and the standard of maintenance can be imposed as well. Now, the occupier, the landowner, has responsibility for any existing features, but in the case of new features, I know that the local authority can contribute up to 25% of the cost. And again, I think there's been a previous speaker who's confirmed that Kent, the local authorities in Kent, do contribute that 25% and usually provide the structure for the landowner to then install. So it's useful, if you're considering that, to contact the landowner. Obstructing a public right of way is a criminal offence, and it's the responsibility of the landowner to make sure that they're not obstructed. There are also responsibilities for maintenance of the surface. Now, if it's a highway maintained at public expense, then it's the local authority's obligation. So it's worth checking. And finally, just before I move on, just to say that there are minimum widths of footpaths and bridleways, particularly on field edges, that should be maintained. But that's not to say that if it's a historic or an express public right, there can be as much wider. I've seen 3 meters recently as a public footpath, so check it if you're thinking about putting a fence up. And then in terms of liability, the liability issue is slightly different. There are slight differences between occupiers' liability for private rights of way and permissive rights as opposed to public rights, and that's because one is a lawful visitor and the other is not. The Countryside and Rights of Way Act, for instance, provides particular exclusions, as does the Marine and Coastal Access Act. So it's important to check, and I think that will probably come into part into your insurance when you're deciding which insurance you need to take out. But generally speaking, the duty of care is to ensure that you're doing what's reasonable to ensure that visitors on your land are reasonably safe. The other thing to consider is negligence. If you owe a duty, you breach that duty and harm is caused as a result, that you have potential liability there. And separately from any damage or injury that's caused, you can't unlawfully interfere with a right of way. That imposes criminal liability if it's a public right of way, but you can have the nasty end of an injunction claim if it is a private right of way. So coming on to the trespasser topic, which is always a contentious one and one that I frequently get asked questions about. You do owe more limited duty to a trespasser, and it generally only will come into play if you are aware of a danger, that you know trespassers are likely to go onto that particular area or piece of land, and the risk is one where you ought to reasonably be expected to offer some protection. And the age of the trespasser will come into play. The children are frequently trespassers as much as adults. And if there is something particularly attractive to them, a fallen tree that they want to climb on or something similar, then that will be taken into account, even if they're not supposed to be there. Fencing is always the greatest deterrent, but that can be expensive. Signs as well will assist. There are criminal offences and there are prosecutions where trespassers have gone onto land and injuries have been caused. There's no get out, but the prosecution level is generally quite low. And I'm always asked about what a landowner or an occupier can do about trespassers. And the unfortunate answer is always very little. Quite simply because generally we don't know who the people are. So tracking them down is always an issue unless you've got their names and addresses. Your remedies will be limited to damage. And if they've just walked across a different part of the field, what damage have you suffered? It might be nominal. One of the more frequent claims that we do and can bring is claims against trespassers who remain in occupation, so travellers that come onto land. Where they remain on land for any period of time, you can obtain a possession order and remove them. And that can be obtained against persons unknown, but they need to be in occupation of the land at the time you make the application. So you can't apply for a possession order against the public at large. And then very briefly, just some comments on livestock and animals. Non-dangerous animals, for example, cattle, you can be responsible for their injuries that are caused by them, but there are also exceptions. One of those exceptions is trespassers, where the person has voluntarily accepted the risk. So if you put up signs warning them and they've gone into fields where they shouldn't be because they are trespassing. There are some animals that can't be kept near public rights of way. Ostriches, camels are on the list. They'll be infrequent, but if you do have something outside of the norm, you need to check whether you can keep it on land. Dairy farmers, cattle farmers will know that you can't keep a bull over the age of 10 months from certain breeds anywhere near a right of way. And if the worst does happen and somebody is injured on a right of way, report it to the HSE. Catherine and I were in a meeting this morning talking about exactly that you need to make sure that you report it to the health and safety executive. And dogs are always a contentious issue. There are certain rules and regulations, but enforcing them is particularly difficult. And sheep worrying, livestock worrying is a criminal offence, but actually catching the person doing it is particularly difficult. There are rules about keeping dogs on leads, particularly on certain countryside and Rights of Way Act tracks for certain periods. But I think, again, it's very difficult to enforce. Now, hopefully, we've just got a couple of minutes very briefly just to talk about tenancy provisions, which comes into a bit more of Catherine's area. But I'll briefly say that encroachment, there are generally provisions certainly within farm business tenancies and later AHA tenancies for tenants not to allow encroachment. It would be a breach of the tenancy to allow that. And when I talk about notices that are given for definitive map modification orders, there's a responsibility of the occupier to pass those on to the landlord and to make sure that they're given, and generally then to assist the landlord in fighting those cases. There are provisions to comply with the law, and any breaches of the law. So, for example, if you interfere with a right of way, tenant farmers need to be mindful of the landlord's reservations. If they think they're challenging members of the public, they may be challenging people who have separate rights of way. And finally, just on landlord's remedies, if you were, as a tenant farmer, to allow a new public right of way to be created over time, there's the potential for a notice to quit to be served, or for damages. And in the case of an AHA tenant, I think it's likely that you get a KC notice if you were allowed to permit a new right of way to be created. So there's some risk there for tenants. Yeah,
it's quite a harsh remedy, really, isn't it? So these rights of way really got to, be aware of these notices coming through at the post and action them, because you don't want to be in that situation. Tom, I'm conscious of time. I think you've rattled through a huge area there.
I have. I think we're at the end, so we've managed to get through it. Sorry for running over slightly, but I try to get through as much as I can.
I think you could spend a lot longer on what you've gone through, Tom. It's been really interesting, and thank you, Catherine, also for covering that. I think what it kind of highlights to me, Tom, with what you've covered there, is the sort of level of complexity really that is around this issue in terms of us as farmers, particularly in those areas where there is a lot of public access, being able to, if you like, get the right solution. And as Pippa said, we need to try and engage with people, but I suspect the real problems are with those people who don't really want to engage with us. So that may be something we could sort of cover. But thank you all very much for that. I think it's sort of really fascinating and lots of food for thought in there. We have got a bit of time for questions. We've had a few on the evening. We've had a few that have been sent through, and there are some sort of common themes. So if it's okay with you guys, I'm going to lump a few of them together and sort of ask you to cover them. I think initially there are quite a few sort of questions and comments about how we manage the situation where people are willfully, as Alan Grindle from Gloucestershire says, using private land as their backyard, as in a kind of I can do what I want here kind of thing, even when there are footpaths available, and how we manage that. On a similar theme, Robert Armstrong from Hexham asks that he's got walkers that won't go through the field because there are cows in them. So but there is no other right of way. What should or could he do in order to allow people to go somewhere else, or indeed insist that they go through the field where the footpath is? And on a sort of similar topic, well, two similar things actually. Robert Richardson points out that he's got areas which are not for public access and are conservation areas, put signs up, very quickly destroyed, and has had several instances of what appears to be kind of quite unpleasant, the things we really don't want to hear about, like dog attacks on dead sheep and damage to property and so on. So what can be done in that situation? And finally, on a similar theme, I hope these are all kind of sort of similar together. John Hatt from Goring Heath, I think you've probably seen this question that we sent out previously, but the general gist of it is that he has some woodland, he has public footpaths and a bridle path that go through it, but there are some sort of other paths that are being made to join those footpaths together. And what should he do to ensure that they don't become public access, even though he's sort of, I think he intimates that he's sort of reasonably happy for people to use them, but obviously he's very wary of what he might be letting himself in for. So I don't know if we could perhaps cover a sort of general view of what we do with when people aren't behaving as we would like them to. I don't know who wants to go first on that.
Well, if I do the legal answer very quickly, and then hopefully Pippa can come in with some more practical advice.
Yeah, great.
in terms of the legal issues, the remedies are limited. If you have trespassers coming onto land or refusing to go along paths because they don't want to, because they're nervous about cattle, you could grant a permissive alternative route. That would be one way of doing it, and that way you control the route that the individuals take. In terms of enforcing that, it becomes quite difficult unless you have fences very clearly guiding people where they need to go, or you're locking gates or making it physically impossible. It does become quite difficult, and that's where Pippa's more personal approach is probably the better way to go, because the legal remedies become quite difficult to enforce against individuals.
I think, Tom, if I can chip in there, I think also there's the Section 31 procedure under the Highways Act 1980, which is really useful for depositing plans with the council, saying you'll recognise public rights of way, what you agree, what is on the ground, and then that stops the clock running that 20-year period Tom was talking about earlier for the creation of new rights of way. So that's a really useful process as well.
Yeah, I'd agree with that the landowner declaration of rights of way is really helpful, and it's non-confrontational, so you're not having to put up signs and keep putting up signs and keep challenging people. You just do that declaration. It's a one-off process. You have to renew it every now and again, but it's a very rigorous process. So far better than, in my view, it's far better than trying to always be putting up signs saying private, no right of way, which you then have this battle about. They might get taken down, or they might slow down, or they fade, and then you're into a degree of debate about whether or not the sign was legible, whether it was been grown behind hedges or something. Just coming on to what you can do, and I do sympathise, and there are some members of the public who are difficult. Let's just put it like that. And I would urge you to carry on doing the friendly farmer approach and be friendly farmer to as many people as you can meet. And I would also suggest that it's really helpful to go around with duplicates of all those signs that get taken down in your tractor cab or your Land Rover or whatever you drive around in. Take duplicates with you that you can just, that's hopefully laminated, so you can just stick them up whenever you come across a sign that's been taken down. Because if you keep putting them up, sometimes people stop taking them down because they just give up. Can't promise that, but it's one way of tackling the issue of signs coming down. But I'd also encourage you to carry on talking to people about why things are conservation areas, why you don't want the public walking in those particular places, and also perhaps have on those signs about conservation areas, where does the public right of way go? Make sure that people are really aware of where that is. I know that doesn't always work, and I'm very sorry about the dog attacks and dead sheep and dogs chasing horses. And I can only suggest that keep on putting up the signs about my sheep are in this field, your dog needs to be on a lead in this field, so that people are really conscious of that is where the dog needs to be on a lead. And apart from that, also talk to your local dog walkers as much as possible. They're always out and about. They're out and about every day, and encourage them to stop their dogs from running up to people. And it is difficult, I do know, because somehow dog walkers don't think that a dog rushing up to somebody else is a problem, because they think their dog's nice and cuddly, and they don't. Quite a lot of dog walkers have a bit of a blind spot. But if I was you, I'd also take a bit to social media. If there's a local social media group, I would post on there, because what you'll find is if you're very measured and very supportive of public access, but say you're having these issues, a lot of people will come in and back you up. And what you're trying to do is you're trying to shift the local public opinion in your favour, in favour of legal access with people doing the right thing. So those are suggestions, and I hope some of them work.
Okay, Thank you, Pippa. I think we are at 8 o'clock, but I'm just going to run on for another 5 minutes or so. If you guys are happy to just stay, just to try and wrap up a couple of things. If you disappear, I'll take it that you weren't happy to stay, but hopefully you are. Or maybe your Wi-Fi's just gone. Just expanding on that slightly, Pippa, in relation A to the conservation area and B, a point raised by Helen Radmore in Devon around the widths of footpaths and how kind of over the last, over this last autumn and winter period, those footpaths have been sort of slightly widened by walkers wanting to avoid muddy areas or whatever. And I can understand one response would be, keep the footpath in good condition. But as we all know, it's quite hard in lots of these places where you've just got soil and grass or whatever to maintain those through what was, for example, in January, a very wet winter. So where do we stand though, Pippa, on, for example, that footpath now encroaching on maybe a margin that's in a stewardship scheme, or indeed in a conservation area, which may be under all sorts of stewardship or SSI agreements, but are actually being damaged, if you like, by the public access on it. How do we stand with stuff like that?
I can't actually speak to the RPA because public access onto buffer strips and things like that is a matter for them. But they have become sort of more outcome focused and less punitive. So I would say if you are actually having issues of the public going on to conservation areas and you're ending up with problems, then talk to your RPA person if you think there's an issue. More generally, yes, if you know there are some specific wet bits, I would be talking to the local highway authority about improving them. And because people tend to avoid the wetter bits, and that's where the issues are. So is there a possibility that the local highway authority could improve them? Or if they're impacting upon you sufficiently that you think, well, actually, it'd be worthwhile me doing a bit about them, maybe approaching the local highway authority and offering to do a bit of work to improve the drainage around the public right-of-way if it's particularly bad. Other than that, there is also an issue of for a lot of public rights-of-way, there is no defined width. The path is as it is, and there's no defined width on the definitive statement. So often the path is as wide as it needs to be. So you may have some issues with how do I stop people from making the path a bit wider? Well, the question is, how wide is the path? So I would tend to suggest talking to your local highway authority if you have an issue in particular places about paths, particularly if people are making them very wide. I've seen some pictures of paths getting to be 11 metres wide this year. I dare say we had particular problems this year as well because we had wet weather coinciding with loads and loads of people being out for the first time. So whilst we all want more people to be out in the countryside, probably there won't be as many people next winter. So it's unlikely to be quite as big an issue next winter. That's if COVID restrictions don't go on.
Yeah, exactly. Thanks, Pippa. Tom, just on the width one, Tom, I was interested, you commented that the footpath was 3 metres wide, as if there was a sort of standard width of a footpath. Is there any legal footpath width that we ought to be aware of, or is it pretty much as Pippa describes it, it sort of is a footpath?
The government guidance is of a minimum of 1.5 metres for a footpath at the edge of a field, but that is the guidance, and it's only in respect of those that have been prescribed by statute. Other things like from the older enclosure acts, like I said, I've seen one that specifically said 3 metres wide for a footpath. So it is a case-by-case basis. I know that I was walking in Derbyshire last year and it was 0.5 metre at best in most places. So it really depends. But there are, for open fields, the government says 1.5 metres is the minimum width for a footpath, 3 metres for a bridle way. But that is just a specific example from the government.
Okay, thank you. I'm just going to ask one final question, and then if you could perhaps be good enough to pick up a few of the others after, and we'll publish them online on the website. Michael Summers, and there's a couple of other people around cyclists and motor vehicles and motorcycles, which I think is perhaps more of a problem, you know, as these vehicles become more easily accessible and mountain biking and whatever. Is there any precedent of byways being downgraded, as it were, from, you know, down to footpaths only or whatever? And how do we do that if motorcycles or whatever are becoming a nuisance? And in a slightly connected way, Lionel Shaw mentioned sort of cyclists and the problem with them on public rights of way, you know, causing sort of certain issues, and I guess certainly being unable to stop and look at a countryside code that's put up there. So how do we access those people? But I guess the first one is a legal thing around byways being downgraded and whether that's a possibility. And the second one, perhaps more for you, Pippa, around how do we get the message across to these users who aren't stopping necessarily?
In terms of downgrading, it is theoretically possible, but the legal maxim is once a highway, always a highway. And if you have a byway, it would be difficult to downgrade that to a footpath. You would be subject to considerable legal challenge. That said, I've seen cases where stopping up orders have been made to change a byway into a footpath where it's been deemed appropriate. So it is possible, but it will be treated on a case-by-case basis. The approach I think that the local authority would prefer is to put features in place such as kissing gates that make it practically difficult for motorbike cyclists to use routes. And that might be their preferred option. A stopping up order requires the local authority's agreement, so they may want to explore other options before they go down that route. Okay,
thank you, Tom.
Hi, sorry, I'm back. I got dropped out.
Yeah.
Don't know. Did Tom cover traffic regulation orders?
I didn't know.
That's usually the way if a local council has the grounds to remove vehicle access on a byway. There's some guidance called Making the Best of Byways, which if you search for it, you'll find it, which describes the grounds under which a local authority can make a traffic regulation order. Some local authorities are fine about doing that, others are very hesitant. So I would talk to your local highway authority if it's an issue.
Okay, thank you. Well, once again, thank you very much. We have run over time. Timekeeping is not my best quality at the best of times, but I think it probably also highlights the sort of complexity of these issues. And I guess for me, a bit of the take-home message is that actually what we have to do is engage with the public as best we can. But sadly, there seems to be limited remedies for stopping those percentage of people that are intent on not doing the right thing, other than just trying to educate and encourage people to do the right thing. So I will just finish on a point that John Wibberley's made about a friend of his who changed his notices from black and white writing to a sort of a green and white lettering, and immediately the vandalism stopped. The assumption being that people believed it was a National Trust sign and respected it. So maybe that's a bit of a take-home message, is that we shouldn't be all black and white and in people. Well, I don't think we're in people's faces, but we should take a slightly different approach. But anyway, I think we do try our best to encourage people to come out and do the right thing. It's been a very interesting topic. Thank you, Catherine, Tom and Pippa, and thank you, Linda, once again for highlighting some of the insurance issues that cover this area. Apologies to anybody whose now tea is cold, or in George's case, his beer is now, his glass is now half full rather than half empty. But so I hope everybody's had a valuable evening. Just a quick reminder, we have got more webinars coming up through May and June. In May, we'll be covering some Welsh issues. We've yet to get a date from that because of the Welsh election coming up. And then the next one will be on the 24th of June at 7 p.m, which will be with Janet Hughes, who's the Programme Director for the Future Farming and Countryside Programme at DEFRA, which covers elms, productivity, and pretty much everything else that we're now going to get faced with. So that's a date for your diary on the 24th of June. Hopefully between now and the 24th of June, we'll have had a bit of rain, so we'll be a bit happier and a bit less grumpy. And once again, thank you very much to everybody, and have a nice evening.